The judgment in the Gupta-owned enterprises versus the Bank of Baroda case will be handed today. The group, whose accounts are facing closure by the bank, is seeking urgent relief to compel the Bank of Baroda to extend their termination deadline. The Bank of Baroda is the only bank conducting business with the companies after almost simultaneous severing of ties by 4 major banks. Oakbay counsel say there is no proof of reputational damage to the Bank of Baroda over business ties with the Gupta family-owned enterprises. Here are the arguments heard in court. The Bank of Baroda argued that it faces reputational damage if it continues association with the Gupta-owned companies. Oakbay Group then counters that the reputational damage, if any, is not related to the applicants. Applicants say that no proof has been provided to show any loss of clients, revenue or employees leaving the bank over the issue. The Bank of Baroda says that they fear further fines by South African Reserve Bank for failure to monitor suspicious transactions. Oakbay says the bank was fined for issues not related to Oakbay companies. It questions the bank that of the 72 reported suspicious transactions, only 5 were from 2017. Why didn't the Bank of Baroda sever ties in 2016? The Bank of Baroda says they want to close accounts due to adverse publicity around them. Oakbay says the bank is relying on invalid, irrational and unlawful grounds in its assessment. Further, several companies had no adverse publicity why close their accounts. The Bank of Baroda says there is no constitutional right to a bank account in good faith or reasonableness. This is to counter applicants' argument that cutting of ties is an infringement of their constitutional right. The Bank of Baroda questions the arguments of livelihoods at stake, saying that they do not pay salaries, pay agents do. But Oakbay Group clarified that the banks pay the pay agent who pays the employees.
Of reputational damage is actually fallacious, and it's fallacious for this reason, because if the court orders the bank to keep these accounts open, that's a perfectly acceptable reason for them to put up in the marketplace. So, my lord, to put it simply, if they say to your lordship, we are suffering such great reputational harm that this will completely undermine our business in the next 2 months, what I'm submitting is your lordship doesn't accept that as at face value.
One would imagine then, if there was serious reputational risk, that the information exclusively within the knowledge of the bank, that it has lost clients. There is no word of evidence that a single client has terminated its relationship with Bank of Baroda, that it has lost employees who are not prepared to work for it. There is no single allegation of that in the papers. There is not a suggestion of the turnover. In fact, they complain that the turnover has increased. The amount of work that they get from the applicants has become impossible for them to deal with.
As the court case resumes in the Bank of Baroda versus the Oakbay saga, it was on Tuesday when the workers at Oakbay-owned mines in the northwest and in Mpumalanga marched to the banks. They submitted a memorandum to the banks demanding their jobs be saved and the bank accounts be opened.